case come before the court is Belmonte versus Belmonte, and it looks like you just have the appellant argue the case, since there's no brief from the appellate.
Thank you very much.
You will have 15 minutes.
Can I say five from rebuttal? May it please
That
the
might be
court.
interesting to watch.
May it please the court, my name is Leslie Grasky, and I'm here on behalf of Brendan Belmonte, who for a long time thought he was the father of a little girl. It is the purpose of the CPO statute to cease domestic violence. It's intended to protect people who are in danger of domestic violence. The record in this matter does not establish that the wife and the child were in danger of domestic violence. In fact, the testimony that wife presented is contradictory at best, but assuming it occurred 2 years prior to her deciding to file for a CPO, and there is no related statement by her that she was in fear of current domestic violence. This court has recognized that you don't look at the history unless there's current fear. The allegation that Mr. Belmonte was naked in the vicinity of the child he thought was his is sketchy, but assuming it's accurate, it is that he was under a blanket in a bed with a child who's fully clothed, and he's not touching her. That comes nowhere near the sexual conduct or sexual activity required by the criminal statute to bootstrap that contact into a domestic violence situation. Again, that was investigated by CSB and found to be unsubstantiated, and Mom moves back in with Dad after that because there really was no problem. Why did she finally file? Because she became engaged, while she's still married to Mr. Belmonte, to a registered sex offender, and she posted that on Facebook, and this is in the record, and it made Father concerned about what he thought was his child. So he texted the grandmother and said, "Where is my child? Where is my wife?" And he asked the sheriff to do a welfare check because his wife had moved his tiny child in with her fiance, the registered sex offender. That is when she suddenly became fearful, and she was fearful for good reason because he was concerned about the welfare of the little child and her proximity to a registered sex offender. The wife acknowledged that husband had made no threats to her safety. The evidence of the incident between them, wife testified, I think, that he pushed her down the stairs, and then grandmother comes in and says he dragged her down the stairs. Well, those aren't even possible to be the same incident, and Mr. Belmonte testified that that never happened. There's no police report, there's no medical evidence, there's no photographs. There isn't even testimony that she had pain or that she was bothered, which this court has required in a case where the mother had repeatedly thrown things at the children and one teacup bounced off a wall and hit the child on the bounce. This court rejected a CPO in that situation. Clearly, this court should overturn the CPO in this case. We've subsequently learned that Mr. Belmonte is not the father of Chloe, but this impacts his ability, and more importantly, Chloe's ability, to have contact with him and his family in the juvenile court case that relates to mother moving the child in with a registered sex offender, and, as is in the record, permitting him to babysit her while she is at work. There is no basis for the trial court's finding that it wouldn't review his objections because they weren't numbered. It's really troublesome that the trial court used a non-existent and highly technical reason for rejecting a great part of his argument. However, if you remove that part of the argument, this record is still insufficient to grant a civil protection order against Mr. Belmonte. The registered sex offender becomes such an issue because it also adds to the lack of credibility of the mother and the grandmother Yeah, we know he's a registered sex offender, but he's got a lawyer now. That's all gonna be straightened out. But boy, they were really anxious to get Mr. Belmonte out of the house and out of this child's life, where there would be someone to monitor her and see that she is all right. The mom brought in texts from father, but they're saying, where are my kids? Where is my kid? Where is my wife? There are no threats. He knew where wife worked. He didn't go there. He knew where wife was living. He did not go there. He did not do any stalking activity. He did not engage in any physical threat of her. Even if one accepted the 2-year-old push-pull situation, there was nothing current. There was no testimony of fear. There was no testimony of harm. The nakedness, if true, is not sexual contact. It is not sexual activity. CSB found it to be unsubstantiated. The wife in this case used the CPO as a tool to get prying eyes off of her. This should be rejected by this court, and we would pray, particularly in light of the trial court's hyper-technical rejection of appropriate objections, that this court issue the order removing the CPO so that we can proceed in the juvenile court case and seek some, it's the Grandparent Visitation Act, but in relationship visitation for this child with the guy she knew as her daddy all those years, the guy who is not a registered sex offender. We would ask that this court make a rejection of the trial court's order, make it pursuant to the appellate rules, and please make it soon. Thank you so much.
Thank you. Council, as you know, will take the matter under advisement, issue a written opinion, and post